Hello students, welcome to KANISHKA IAS. This is Reddy. We are going to discuss an important topic, that is the difference between parole and furlough. Because the topic called prisons is being asked very frequently in the UPSC preliminary examination. So in order to answer these particular questions on these prisons, definitely we need to have some basic information about them. So in this video we are going to clarify the same. Coming to the question that was asked in the UPSC prelims, with reference to India, consider the following. Statement number 1 is, when prisoner makes a sufficient case, parole cannot be denied to such prisoner since it is a matter of his right. And second one is, whether the state government have the power to make their own rules or not. This is the second statement. So these four options have been given. So let us get into the topic. In fact, the prisons fall under state list. So prisons fall under state list. So particularly under entry number 4. So originally this power to enact the law on prisons is vested with the states themselves. Why? Because this fall under state list. Okay, you need to remember this particular thing only by logic. Okay, basically the state list contains the matters which are of local or regional in importance. Any matter which is local or regional in importance will be falling under the state list. Okay, so the logic is simple. Those matters which are of national importance. Basically, in order to identify which subject falls under which list, the union list contains the matters of national importance. Not only that, any matter which is related to the uniformity of legislation, at the same time that matter must be under the competency of the union executive and competency of the union legislation. That is nothing but union subject. For example, you can see the subjects like banking, currency, defense. These are the matters of national importance. So they definitely belong to the union list. And coming to state list is a subject matter which are of local or regional in importance. So local in the sense that they can be better controlled or regulated under the system of decentralization. Okay, the constitution recognizes this decentralization in the form of the foundational principle, that is nothing but federalism, where state governments can operate independently, free from the central government control. And moreover, those matters which are related to both union level importance, that is national level importance, as well as state, that is regional importance. For example, you take the subject matter called as education, forest, criminal justice system. So these are such kind of matters which are of both nationally important as well as regionally important. So on these subject matters, both union legislature can make the laws and state legislature can also make the laws. But in the case of inconsistency, union law prevails over the state laws. So that is how we need to understand. So instead of blindly by hearting the things, we can simply remember through this particular logic. Okay, right. So that is the reason why states have the power to make their own laws. But British government already enacted various laws with respect to the prisons. Okay, because we continued these laws even after the independence, because they are very much useful even in the independent India. Because our intention of governance has changed. Okay, laws need not be changed always. Hence, we have continued the union legislations. For example, union laws such as Prisoners Act, Modern Prison Manual, which is circulated by the central government, and Transfer of Prisons Act of 1950. Why? Because India is such a vast country. So the vastness will be leaving a lot of diverse issues and diverse problems. Every state may be having the power to enact their own laws, but the laws must be consistent with each other. The laws must be respecting the broader and general principles. Such general principles to be followed by the laws have been given in the form of Prisoners Act of 1894. This is what a general legislation which will be like a guidance for the state specific legislations. And there is also Modern Prisons Manual, because the prisons are being overcrowded and there is also issue of human rights violation. That's why the Union Home Ministry has circulated this particular prison manual. Moreover, Transfer of Prisoners Act. The prisoners, the crime cannot be located to a particular state. The crime can be having the links all across the India. So naturally, the prisoners' movement is also very much important. How they facilitate the movement of prisoners from one state to another state is also facilitated by union legislation in the form of Transfer of Prisoners Act of 1950. Moreover, certain states have their own laws. For example, Karnataka, Kerala, Rajasthan, Andhra Pradesh, Tamil Nadu, they have their own legislations. Okay, so that their prisons will be governed under their own legislations enacted by the legislature. But the rest of the states have made their own rules. Okay, the rest of the states have made their own rules. Generally, rule making is power of delegated legislation. Executive power to make the legislative process. Okay, generally the legislature gives the power to make the rules to executive. Accordingly, the state governments have been given the power to make the rules under the union legislation. So this is how few states have enacted the laws and rest of the states have made their own rules. Okay, without having any specific legislations. And irrespective of the fact that whether a state is having law or rules, the prison rules or the prison laws will be governing the various aspects like administration, management of the prisons and rights of the persons. These are the things which are regulated by the prison laws or the rules. So this is what the chronology we can see. Okay, laws will be helping to formulate the rules and rules will be the source for the formulation of the prison manuals. These prison manuals will be changing from state to state. So naturally, certain procedural aspects of the prisons will definitely change from state to state. Okay, substantive aspects may be similar, but the procedural aspects, how parole shall be applied, how furlough shall be applied, but substantively all are similar only. Okay, that is ensured by the Prisons Act. Then we have seen laws will be leading to rules, rules will be leading to prison manuals, and the prison manuals vary from state to state. And broadly, what do these prison manuals cover? The prison manuals cover prison management and discipline, parole and furlough, that is nothing but temporary or conditional release of the prisoners from the prison, health, hygiene, medical care, education and skill development, visitors' rights and communication. Next important thing is rights of women and juveniles. So these are the matters which are covered under the prison manuals. Just now we mentioned the prison manuals contain the paroles as well as furloughs. Both are nothing but the conditional release of the prisoners from the jail. But you understand what is the difference? So before we understand the difference, let us understand the commonality. Okay, both are stemming from the prison manuals only. Okay, prison manuals, and they fall under the domain of executive. So this is very important. They fall under the domain of executive. So it means judiciary does not grant. Who will grant? The executive or the government. Which government? State government we usually granting this. And moreover, both are conditional releases. Conditional releases means both are granted in the case of good conduct, not have committed specific offences. For example, terrorism or any heinous offences must not have been committed in order to get these particular temporary releases or conditional releases. Right. And coming to the differences, the parole and furlough, if you try to find out the differences, parole is granted on account of specific reason. Okay, specific reason means, for example, a prisoner may be a farmer. A prisoner must have gone to harvest the crop, or his requirement is very much mandatory at home. Okay, the marriage of children or the death of the relatives. These are the specific reasons why the parole shall be granted. And parole shall be granted number of times. It can be granted number of times, but it is not a matter of right, but it is granted at the discretion of the executive whenever the emergency is seen. So, and moreover, it can be granted number of times. So, any number of times you go out of the prison, that cannot be included into the total time of the imprisonment. Suppose on the name of the parole, he is outside to the jail 1 year, for example. At the stretch 1 year may not be granted, but for example, cumulatively 1 year time is there, okay, who is outside to the jail. That 1 year time is not included into the total years of the imprisonment. So that thing you can understand. Coming to the furlough, it is to be granted to break the monotony of the imprisonment. Basically, the prisoner should have a motivation to pursue the good conduct in the jail, or he must be having the hope, in future I will be getting good life. He must feel the purpose of his imprisonment. He must own up the cause of his imprisonment. In order to ensure this, he is permitted to go and integrate with the society, to restore his family ties, to restore his societal ties. So that particular thing is granted by the furlough. And in the case of parole, it can be granted any number of times, but there is a limitation on the furlough. So furlough cannot be granted that routinely and that easily. And usually this furlough is granted in the case of long-term imprisonments, whereas parole is granted in the case of short-term imprisonments. It is short-term imprisonment, it is in the case of long-term imprisonments. Moreover, the parole is generally, it is falling under the discretionary power of the executive. You can't demand this must be given on the basis of your legal entitlement. But what is a legal entitlement? The furlough is a legal entitlement. Why? Because it is a substantial and legal right. It was also already recognized by the Supreme Court. So hence it is a legal right. And coming to the parole, the prisoners must report to the police station and return to the prison. So as long as you are outside to the prison, you must be frequently reporting to the police station of that particular locality, and you need to return once the parole is completed. And coming to the furlough, the rules may be varying from state to state, but at the same time, the term under the furlough is inclusive of the total duration of the sentence. Okay, for example, if the person is outside to the jail for 1 year in different phases of his furlough, cumulatively it is 1 year. Suppose if he is imprisoned for 10 years, out of 10 years, 1 year is deducted. So that is what called as furlough. But the rules regarding the furlough may be found change from state to state, only in the matter of procedure but not in the matter of substantive aspects. Okay, substantively all the rules will be having the same essence. This is an important point where the under trials or detainees are not eligible. Okay, so this particular right is applicable only in the case of convicts. Of course, two things we need to understand. Parole is not right, whereas furlough is right. This is very, very important. And this is exclusively available in the case of convicts. And both have the commonality is that both are granted on the basis of conditional basis. Moreover, this is not applicable every time in the case of terrorists or any kind of heinous offense, or the person who got convicted in the heinous offenses. Of course, it is a matter of power that is vested with the government. Coming to the Supreme Court judgments, Supreme Court in various judgments, particularly in the case of Home Secretary versus Nilofer Disha, in which Supreme Court held that parole is not right but discretionary power of the government. And moreover, State of Maharashtra versus Panduranga Divakar, the Supreme Court held that furlough is matter of right, shall not be denied in valid grounds. So I told you whatever the points which I have explained you, these are all outcomes of the various judgments. And Ashfaq versus State of Rajasthan, in which Supreme Court emphasized parole is need based, whereas furlough is meant for social reintegration. Okay, I told you these points also. Coming to other aspect, what is probation? Probation is nothing but conditional suspension of a sentence, where the person is placed under the community supervision. So the person is generally exempted from the imprisonment and kept under the community supervision, so that he will be able to change his mindset. So that is what. So that's why it is nothing but a rehabilitative measure. It is not a kind of a punishment, and it is not granted for the serious offences. For example, in the case of juvenile delinquencies or any kind of minor offences, there is a chance for the kind of probation. And the probation is specifically under the Probations Act. There is a special legislation enacted by the central government to regulate the probation. Then coming back to the question, it is very easy to answer this question now, right? So when prisoner makes sufficient case, parole cannot be denied to such prisoner since it is a matter of his right. I told you Supreme Court has categorically held that parole is not a matter of his right. And moreover, state governments have their own prison release manual, or they have the power to make their own rules. Yes, what is the right answer? Obviously, you can easily mark the right answer. That is nothing but only 2. So this is how we need to understand the concept and apply our knowledge. Thank you. Please watch KANISHKA IAS YouTube videos and be subscribed. Thank you.